So for this next part, I want to look at the Florida statutes that Gabi calls out in her supplemental factual statement that she filed as part of her injunction for an RO. She calls out 784, 048, 1A, and 1D. So this is part of her legal strategy here. So let's read these. So 784, 048, 1A says, harass means to engage in a course of conduct directed at a specific person which causes substantial emotional distress to that person and serves no legitimate purpose. And then if we come down, we're going to look at 1D. This is the big one for Gabi. Let me zoom out. Cyberstalk means to engage in a course of conduct to communicate or cause to be communicated words, images, or language by or through the use of electronic mail or electronic communication directed at a specific person, causing substantial emotional distress to that person, and serves no legitimate purpose. Serves no legitimate purpose. So she's just going to ignore everything else in here. But I take exception to the serves no legitimate purpose. Because Gabi's own words, when it comes to her live streams, you know, when she's got all of these welfare checks that get called in on her, and that can either, there is literally no proof of where those calls are coming from, by the way. Even outside of this case, there's no proof because, again, the algorithm is going to push out her live stream on YouTube based on the engagement. So if YouTube sees, because she likes to rage bait, a bunch of people jumping in, there's a lot of interaction in this live stream, her mods are selectively deleting comments. Like, by the way, guys, never go into her live stream because that's all part of it's part of the hook. Because if YouTube sees a lot of engagement, they're going to push her live stream out even more. So like YouTube has that element of where you can just scroll through videos and you can scroll through lives. But when she gets called out on these things and her behavior, and people actually do call welfare checks in, she says that it's nonsense and pathetic. And she's told her chat before, jokingly, this isn't an emergency. So under Florida's objective, reasonable person standard, a circuit court judge cannot find that an action causes substantial emotional distress when the petitioner herself broadcasts to thousands of viewers that certain situations are pathetic nonsense. Her casual on-camera behavior legally disproves the presence of a severe actionable trauma required by the statute. So if you go back and we look at the event that caused this, did she seem like she was in severe emotional distress? Did she seem like she was concerned for her safety? No, I didn't think so. So Florida Statute 784-0481D dictates the rules for cyberstalking. It defines this as a course of conduct to communicate words, images, or language through electronic communication directed at a specific person, causing substantial emotional distress. Gabi's entire exhibit packet that was filed along with this supplemental to her injunction for the RO consists entirely of screenshots where Zenny is reposting or commenting on clips from Gabi's public live streams. Here's the statutory defense trap for these electronic communications. They are not directed at a specific person. They are reactions to a public monetized video that Gabi broadcasts to the internet first. Nobody goes out, nobody seeks these. Gabi broadcasts these publicly online as a monetized quote-unquote creator for YouTube. Gabi textually admits on a stream that the conduct is driven by people stealing her money and reacting to her public commentary on trials. She's been so obsessed with the Lindsay Clancy trial. But also, if you've noticed this, Gabi is starting, when she did her alleged psychiatric appointment the other day, she kind of mirrored some of the, I've been on this and that and these medications. She's kind of known for stealing stories, allegedly. So, under Florida law, public commentary on self-published material does not meet the statutory definition of targeted cyberstalking. Okay, to try to give her petition some appellate teeth, Gabi cites a landmark Florida case, Logue v. Book. She's citing this case to argue that targeted social media campaigns can constitute cyberstalking even without direct physical threats. And when I say she clearly did not read this case, she clearly did not read this case. This is actually something good. If Gabi's attorney did not remove this from her filings, which I'm not sure if he did or not, this is a disaster. So, just to sum it up, the 4th District Court of Appeal made it clear that social media communication is protected by the First Amendment unless it has absolutely no legitimate purpose. That's the only part that she read. I'm going to have to get Mr. Hand out for this one. The court ruled that public criticism, public advocacy, and exposure of public behavior serve a valid, lawful, communicative purpose. So let's read this, and I will put these on, I'll do some references at the end so you can look this case up. But this came from case law. You go into case law, you look up Logue v. Book. It's Logue. So appellant Derek Warren Logue appealed a final injunction for protection against stalking. He argues, among other things, that the trial court erred in entering the injunction because the appellee failed to prove the statutory requirements for an injunction, and because the injunction is a prior restraint on his free speech. This case provides our court the opportunity to address whether First Amendment freedoms have limits when applied to 21st century communications. The appellee, Lauren Francis Book, who was the petitioner, is a public figure, an elected official occupying the office of Florida State Senator. In addition to her duties in public office, she also runs a nonprofit organization called Lauren's Kids. Can you see why Gabi thought she should do this? But she really shouldn't do this. The entire purpose of Lauren's Kids was to assist survivors of SA and to prevent its occurrence. In both roles, she has been a long-time public advocate for laws that support and maintain SA registries and place residency restrictions on convicted offenders. The respondent is also a public figure, the co-founder of what is described as the anti-registry movement, which opposes SA laws. In that capacity, he travels to, organizes, and participates in various demonstrations and counter-demonstrations around the nation, opposing the type of offender laws for which the petitioner advocates. Whew. In furtherance of this role, he maintains an online presence using both Facebook and Twitter accounts, as well as internet websites. One website relevant to this case is titled Floridians for Freedom, Ron and Lauren Book Exposed. Ron Book is the petitioner's father. The petitioner filed for an injunction alleging the respondent was harassing and cyber-stalking her, which he was. The trial court held a hearing and took testimony from the parties and witnesses, after which the court entered an injunction against the respondent. That injunction was the basis for this appeal. So, let me get this straight. Gabi, what in the world? My flabbers are gasted. So basically, any defense to this is going to argue that the Cam's Law movement and any commentary, even someone driving by locally, don't violate Logue because they served a legitimate purpose. Documenting, critiquing, and responding to footage that Gabi willingly published to the internet herself. Furthermore, Logue v. Book heavily reinforces that emotional distress cannot be based on the subjective fragile feelings of a specific creator. It requires an objective standard. A judge might ask, would a reasonable person suffer severe paralyzing trauma from this commentary? Like, what is a judge going to see from her evidence file? Her own unedited transcripts where she tells her chat recently that she's peachy and great, laughs out loud about maybe needing bail money. Her own psychiatrist from her own live stream last week instructed her that the medical solution to her anxiety is simply to log off the app for 3 to 7 days. Logue v. Book firmly establishes that if you can resolve your digital distress simply by using the power of a button on your phone, you do not have an actionable case for a court-ordered emergency restraining order. So, I'm going to pause on that, go to the next section. Okay, to wrap this up, I want to look at probably the worst aspect of this entire injunction for a restraining order that Gabi filed. So, if you look back at the 784-048 1A and 1D, both of those statutes explicitly require the course of conduct to be directed at a specific person. Her child was not even present during that incident. So, it brings us back to Florida Statute 92-525, which regulates perjury by false written declaration. So when Gabi signed her supplemental petition, she signed it under the mandatory statutory warning that she declared under penalty of perjury. So, lying in a verified pleading is a third-degree felony in Florida, punishable to up to 5 years in prison. So, there's a thing in court under the unclean hands doctrine. You cannot lie on a verified pleading. So, even her own recorded admissions prove that she doesn't meet the statutory thresholds of 784-048 or the case law that she's referenced because of her platform activity. My guess is that her request for this injunction is going to be thrown out. While she thinks this is going to be some big production in court, it's not going to be, because you cannot walk into court with dirty hands. So, next we'll look at the witness list, but I'm witness statements, but I'm probably not going to do that tonight. So if you watch this all the way through, thank you. Feel free to leave comments. Bye.